afternoon, everyone. Those present and those listening over the internet, welcome to the Assembly Committee on Commerce and Labor. Mr. Secretary, will you please call the roll?
Assemblywoman Carlton.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Dickman.
Here.
Assemblywoman Duran.
Here.
Assemblyman Flores.
Present.
Assemblyman Frierson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Martinez.
Present.
Assemblywoman Marzola.
Here.
Assemblyman O'Neill.
Here.
Assemblywoman Tolles.
Here.
Chair Howdigi.
Here. And Mr. Secretary, please indicate that all committee members are present. Before we start, I would like to make our housekeeping announcements. Please remember that all exhibits, written testimony, and amendments must be submitted by noon on the Wednesday prior to the committee meeting. Persons wishing to provide testimony or attend the meeting virtually must pre-register online at the legislature's website. The public is strongly encouraged to submit written testimony in advance of the meeting by emailing asmcl@asm.state.nv.us. Zoom chat is reserved for committee business only. Members, please remember to keep your camera on at all times. This will help us ensure we have a quorum unless you are stepping away for non-committee related business. Members and presenters, please remember to be muted at all times. Unmute yourself to speak and then promptly mute yourself when you are done. Thank you to everyone, and let's begin with our agenda. On today's agenda, we have Assembly Bill 47. I believe we have Mr. Mark Kruger, Deputy Attorney General, here to present. Welcome, Mr. Kruger. I'm now opening the hearing on Assembly Bill 47, so when you are ready, please proceed.
Madam Chair, members of the committee, thank you. On behalf of Attorney General Ford, we are happy to be providing an opportunity to introduce AB 47, which makes amendments to Nevada's Unfair Trade Practices Act, NRS Chapter 598A, otherwise known as Nevada's antitrust laws. Before I get to what AB 47 does, I want to provide the committee with some background on how we got where we are, and I want to thank each and every one of the stakeholders that we worked with to get us here. Many of these stakeholders will testify in opposition to AB 47, but make no mistake about it, the stakeholders in our office worked together long and hard to get us to where we are, and we appreciate their work. We have worked with over 30 stakeholders, had numerous meetings as a group at large, and then we even had individual one-on-one meetings with any and all stakeholders who were interested in meeting with us. We met their concerns with open minds and willingness to make amendments. We started with broad language, and due to the concerns that we heard from the stakeholders, we narrowed our focus, we refined our words, and we sharpened our pencils. And we were not afraid to make the changes, but we also did not lose focus of what we needed to accomplish. And in the end, we believe the legislation that you see here accomplishes our needs without creating an undue burden on the stakeholders. AB 47 has three distinct focuses. Number one, it allows our office to take a peek at consolidation transactions in the healthcare market in Nevada. Number two, it provides clarification and cleanup language to remedies and investigatory authority of the AG's office. And number three, it limits the applicability of non-competitive covenants or non-compete agreements by prohibiting them from being applied to employees paid on an hourly basis, so that those employees are not limited in their ability to get new jobs when they stop working for that particular employer. I'm going to go through each of these three focuses, and in so doing, I will address the objections that we've heard. Section 1 adopts sections 2 through 5 of the Act. And 2 through 6 really rely on the healthcare transaction. Healthcare costs are a concern to every Nevadan, and consolidation in the healthcare industry can increase healthcare costs to Nevadans and Nevada families. Our first focus allows the antitrust team in our office an opportunity to take a peek at the transactions that will affect costs in healthcare and ensure competition in the healthcare market so that costs can be lower. This would include transactions that are not reportable under the federal Hart-Scott-Rodino Act, or HSR, as well as requiring those HSR filings to be sent to the Attorney General's office. We already have the ability to issue a formal civil investigatory demand or subpoena for this information. All we're asking for is the industry to help us out by providing us a confidential, often 1 or 2 page report to allow us to see if a particular transaction in healthcare is something we should be taking a closer look at to ensure the healthcare market remains robust in Nevada. Such an ask is with minimal effort on the industry and potentially great rewards for Nevadans. Under Section 226, the transactions that are reportable under AB 47 include all types of transactions where physicians and other healthcare practitioners experience consolidation through material changes in ownership or control. Examples of the type of notice that would include these transactions are hospital mergers, vertical consolidation of physician practices in larger entities such as hospital systems or private equity, and horizontal consolidation of physician practices. The notice provisions of AB 47 do not create an onerous burden for healthcare entities. For HSR transactions, the entity would send the Attorney General a copy of the HSR filing. For smaller transactions, the entity would submit the 1 or 2 page report, setting forth information regarding the identity and nature of the parties in practice. The notice provisions do not do anything that is not already authorized under existing law by the issuance of multiple CIDs, often monthly, if we had to. The bill simply requires the industry to provide us notice to transactions earlier than we would receive them otherwise. The 30-day time frame in Section 22 is consistent with the HSR filings. All information reported to the Attorney General remains confidential. That was something that the industry and the stakeholders wanted. If there's a material change to the transaction during the 30-day transaction period, it would just trigger the filing of a new report, which again would also be confidential. We note that in some objection, there was question as to the breadth of Section 2, sub 2C, business entities that will provide services. We are willing to edit that to make it a little clearer that it's healthcare or health carrier business entities that will provide services. Anywhere that there is something as an objection that has, we can provide that clarity is an example of how we've worked with the stakeholders to refine this AB 47. The term primary service area is used to give entities flexibility in stating their geographic markets. Businesses are aware of the geographic markets that they serve, and flexibility is important in defining geographic markets because different types of healthcare entities have different service areas. For example, a hospital in a rural county may serve several surrounding counties, or an entity which provides traveling nurses may serve the entire state of Nevada. Sections 2 through 6 of AB 47 are designed to be interpreted together, not independently. And so for clarification, Section 2 provides for notice to the Attorney General, while Section 4 requires that information received pursuant to Section 2 remains confidential. And then Section 6 defines what types of transactions are subject to the notice provisions in subsection 2. Section 6 does not have a reporting requirement that is independent of Section 2 or a different confidentiality requirement from that of Section 4. And I provide that information to clear up any ambiguity about how those sections work together. And it's not the intent of the Attorney General to share or divest authority for antitrust enforcement. And the Attorney General is not looking to delete any of the provisions regarding confidentiality for these types of transactions. The civil penalties in Section 5 are up to $1,000 per day for violation. When civil penalties are awarded, courts have broad flexibility to apply these civil penalties, and the word up to allows for that flexibility. Contrary to some objections, it's not necessarily accurate that a group of practice of 7 is very little. In some marketplaces, particularly in smaller counties, 7 may be a greater number. The question that we have to ask is, what is healthcare market in each locality? If the market is a specialty service, for all but Clark County, there may only be 1 or 2 physicians practicing within a reasonable travel area, such that the consolidation of 2 practices could have an effect on the market. Material changes in ownership and control of public entities does not necessarily present a concern in evaluating the market, and therefore a notice requirement for payers is not included in AB 47. The self-funded entities, including large public employers such as the state of Nevada or counties. The remaining self-funded entities such as casinos and unions do not participate in healthcare delivery as their primary business. Thus, the material change in ownership and control will not increase or decrease consolidation in the markets for healthcare delivery. We note an objection to the term Section 6.6 third-party administrator, and we wanted to let you know that that was a Scrivener's error of sort, and we are deleting that language. The definition of reportable healthcare or healthcare carrier transaction is deliberately broad. We have limited the reportable transactions to activity in Nevada, but the intent is to receive notice of the transactions which affect healthcare provider transactions in Nevada. The notice is in the form of a 1 or 2 page report, as I've said. It's not onerous, and because it's confidential, it should not have a chilling effect on healthcare transactions in Nevada. Moreover, internal transactions which are non-consumer facing may still have an effect on price, quality, and consumer choice. The word affiliation means where one entity has control or power to control another, or a third party controls both entities. We're capturing business affiliations, not marketing affiliations, as an example of a grocery store with a hospital to distribute it. Affiliating with a hospital to distribute flu vaccines. Moving on to sections 7 through 13. The second focus of AB 47 provides our office with clarification as to the remedies we have in investigations and actions under the Unfair Trade Practices Act. And it also provides clarity to the confidentiality provisions of those investigations. There's been no opposition to this section of the bill. Section 12 confirms that the Attorney General shall keep information that is submitted to it pursuant to the administrative subpoena, also known as I said, a civil investigative demand, under NRS 598-110 as confidential, and that the information is not subject to public records law disclosure under NRS Chapter 239 or the Patient Protection Commission under NRS Chapter 439. And finally, moving on to Section 14, the language in the third focus of AB 47 is an example of our office and stakeholders working together. The language or rule of prohibiting non-compete agreements from applying to employees who make an hourly wage came from the stakeholders. The rule is simple in application and understanding, and it protects employees who need the protection. With that, Madam Chair, I thank you, and I will turn it over.
Thank you, Doug Kruger. We appreciate you breaking down the bill for us. It was very helpful for me to have you break it down into sections like that. I am going to turn it over to the committee members for questions, but before we do, I'm going to take the privilege as here just to ask you a quick question. It's regarding the first focus of the bill, which is sections 1 through section 6, kind of. Could you walk us through or give us an example? Has there been a case where if there had been reportable transactions in Nevada, the Attorney General's office might have been able to prevent what I think you call like horizontal consolidation, and that caused healthcare prices to go up?
Thank you, Madam Chair. Mark Kruger, Chief Deputy Attorney General, for the record. I have with me 2 people, and I'm not sure Marie Martin, Senior Deputy Attorney General, was able to get on, but I also have Lucas Tucker, Senior Deputy Attorney General. Unfortunately, while we've been spending a lot of time talking about the confidentiality provisions of the Unfair Trade Practices Act, we can't get into details of prior transactions. But yes, to answer your question, there have been instances of reports where transactions have come to our attention. The only problem is that we oftentimes get notice of those types of consolidation transactions later in time. With an earlier notice provision, we can take a look at them. Obviously, if we do find out about it, and oftentimes working in conjunction with our federal partners, we find out about them, particularly if they hit the HSR thresholds, then we work hard to make sure that there's competition in the marketplace so that there is not an increase in healthcare cost. And we've been successful in many of our reviews when we do find out about them. We are concerned that there are some smaller consolidations, particularly in markets where there are potentially particular, as I described, particular provider groups that a consolidation could drive up costs, and that's why we want to take a peek at them. I will also ask that either Ms. Marie Martin or Mr. Lucas Tucker chime in to answer this question if you're okay with that, Chair.
Absolutely. Thank you, Dad Kruger. And I believe we do have Ms. Martin and Mr. Tucker both online. Ms. Martin or Mr. Tucker?
Yes, Chair and committee members. There have been transactions, particularly under subsection 2, which are transactions that fall below the HSR threshold. The current reporting threshold under the Hart-Scott-Rodino Act is $92 million. As Mr. Kruger said, we can't go into any details about those investigations because they're confidential, but I can confirm that in the past, we actually had a consolidation here in Las Vegas, so not a rural county, that fell below the threshold. And so neither our office nor the FTC knew about the transaction until it was about to be consummated. And in that case, both the FTC and our office was a little concerned. And so we went to the companies and asked them for information. They ended up having to issue a hold separate letter. So they agreed that even though they had consummated the transaction, they agreed to hold the assets separate for a period of time to allow us to get some information about it. It would have been better for our office, and I think also the parties in that situation, if we had known about it beforehand. And so that's an example of a transaction that is captured under subsection 2 because it falls below the reporting requirement under the Hart-Scott-Rodino Act.
Madam Chair, that is a great example by Mr. Tucker. Now, we're kind of looking at a chicken and egg problem, if you will, because we can't share with you confidential information that we get. If we don't get the information regarding smaller transactions, we don't know they happen until sometimes years later, or at least months later, when it's really difficult to unwind transactions. Something that we do know that economic studies will show you, we've been reading an awful lot of them, is time and again, consolidation in markets will cause prices to increase, quality may decrease, certainly choices for consumers decreases. And it's not just the huge, transactions where one or two insurance companies get together and where you get two insurance companies who are combining that will affect markets. It is very frequently an aggregation of smaller transactions where one physician group joins another and they are practicing in a key subspecialty, for example, or a hospital system or a vertically integrated insurance carrier that has a number of different providers integrated into it acquires a key specialty. That particular specialty may not have a huge, you say, well, this isn't going to hugely affect the market. If it's a key specialty, it could allow what we call a vertically integrated system to affect prices in an entire market. And so it's important to look at these transactions and see the effect of them. And, this can be done very quickly. It's really, as Mark said, this is not an owner's burden to give a 1 to 2 page form to us saying, here's what we're doing, so that we can look at it and have an idea of it. So thank you.
Thank you, Ms. Martin. And presenters, I will just remind you for our secretary recording purposes, if you would please just identify yourself before speaking. I do have another question, but I'm going to turn to committee members first. I'm going to move to Assembly Member Considine.
Thank you, Chair Howdy. My question deals more with the non-compete clause and it being solely for the benefit of hourly wage workers. But what I was wondering if there was any discussion or if there's any issues with sort of anti-poaching, which is sort of the flip of that. Whereas when consolidation happens, if there's agreements to not hire on people from the smaller pool of competing entities, that kind of has the same effect of not being able to move to another location with the same skills. Has that been an issue? Was that discussed, or is that a flip side of this in this situation?
Madam Chair, through you, Mark Kruger, Chief Deputy Attorney General, for the record, to Assemblywoman Considine.
Mr. Kruger, please feel free to go directly to the members.
Oh, thank you. Thank you, Chair. We looked at more the perspective of the hourly wage. We did not look at the flip side of it and haven't discussed it yet. That is certainly something that we can have discussions with the stakeholders. And as I said earlier, the stakeholders really worked well with us and came up with this bright line rule of the hourly wages. But we hear your concern and definitely can have those discussions.
Thank you. I appreciate that.
Thank you, Assemblymember Considine. Next, we will go to Assemblymember Flores.
Thank you, Madam Chair, and thank you both for your presentation this afternoon. I guess I want to just take it back and peel back a little bit on getting too far into the weeds. I don't navigate in this conversation enough, so I think I'm going to ask more of a broader question to help me kind of put everything into perspective. Well, I guess the first question is, I understand, and then going off of the response that was previously given, that we don't think it's too onerous to have a 1 or 2 page so that we can see kind of what the agreement is. And obviously we want to promote transparency, consistency, and all that good stuff. But if you could just walk me through how you foresee that playing out. You get the 1 or 2 page document, because the way I see it is, and because of these set requirements of, and I've also been jumping back and forth between the original language and the amended language. So you may have addressed it and I just missed it, but I'm just trying to visualize that interaction, right? We have entity A who has a perspective of entering into an agreement with entity B. They're going to engage and interact. They put something in writing that gets submitted to you. You then look at it. I foresee that maybe there being multiple, well, wait, we need more details here. Please provide more information there. I just want to see how that relationship would start. And then from there, I think I could engage in more questions with the indulgence of Madam Chair.
Assemblyman Flores, thank you. Mark Kruger for the record. We appreciate your concern, and I'll try to take you through it a little bit. And then I'll invite both Mr. Tucker and Ms. Martin to supplement my answer. But basically, it's a very simple process. The report would come into us. Let's say it's an HSR filing. They could use the HSR filing, which is the same one they're going to be turning over to the feds, and just give us a copy of it. And then it would typically, let's go with the other route. If it wasn't an HSR filing and it fell below the threshold, then it would be a form of 1 or 2 pages that would provide us an overview of what this transaction was going to do. We would take that and review it. And yes, we may be able to say, hey, let's discuss this a little bit, set up meetings to talk about it. Or we may say we need additional information. Again, the important thing to note is that we already have the authority under existing law to issue a subpoena or a civil investigatory demand anyway. So that part of the investigation wouldn't change from what we currently have authority to do. This just provides us with notice up front. And as Mr. Tucker gave you in that example that he testified to a few minutes ago, it's a lot easier to know about this stuff up front than having to then say to the parties, hey, wait, we need you to stay for 30 or 60 days or a little time frame in order for us to then do our investigation, which delays their ability to go ahead and consummate that transaction. So with that, I hope I answered your question, and I'll turn it over to Ms. Martin or Mr. Tucker to also provide additional information.
The idea is that we...
Martin, if you would identify yourself for the record.
Sure. Sorry. I've been playing with 2 different mute buttons. Marie Martin for the record. The idea is we receive either a copy of the HSR filing or the 1 to 2 page report. We review it quickly, and we then determine whether or not we're going to send something out. We have within that 30-day period to send out a CID requesting further information. We get that information. In most cases, we would be satisfied, by the way, with seeing the report and saying, well, we don't need to send out a CID. Sometimes we'll say, well, this is a key subspecialty, and we should send out a CID, find out more about this transaction. We find out, and then we make a decision as to proceed from there. It just, as Mark said, this really just gives us a much earlier look at transactions before they occur. And so that is the envisioned process.
Thank you. And Madam Chair, if I could ask a follow-up. Thank you. And again, I apologize for approaching this conversation through such a novice lens. But I wanted to touch upon the previous conversation, which was that they're technically already doing this anyways with the feds. And that you already have the authority to engage in this exploratory discussion. Logically, you wouldn't know to do that because you don't know that relationship exists or that agreement is out there. I completely understand that. And preemptively, you want to know what's happening so that you can raise questions on the front end rather than the back end. Completely get that. So I guess the question I have is, if they're reporting to the feds and then reporting to the state, say the state has a host of questions, is there a scenario where the state or in this case, the AG's office wouldn't want to engage in an exploratory, we need more information, but that the state would have a vested interest in doing that, but that the feds wouldn't? Because what I'm trying to understand is if we're sending this to the feds and then we're sending it to the state, is there a scenario where the feds are going to come back and be asking for the same exact thing, or the opposite of that, which is there's a scenario where the feds will say, we're completely good with that, but the state's going to say, wait a minute, we have an issue here, and that the AG's office is going to do something beyond what the feds would be doing?
Assemblyman Flores, Mark Kruger for the record. Thank you for your question. I hope I can provide a little bit more clarity, and then you also triggered in my mind something you said on your last question, which was you looked at the prior iteration of the bill to what it looks like now. And that's exactly what we were talking about, how we really worked hard with stakeholders to get it to a very narrow focus. And the result is this: if there is a federal transaction that is reportable through an HSR filing, then we're going to work with the feds together on that. Now, if there is a component of that federal transaction that is solely Nevada related, then we may look at that from a Nevada perspective only in conjunction with the feds or by ourselves. And the feds would defer to us if it were Nevada only, whereas in conjunction with them, we would work together to make the decision as a whole. Now, we're also talking about non-federal reportable transactions. So those transactions that are solely within Nevada, and we limited the bill to cover only Nevada transactions. Those limited transactions that are Nevada only, the feds likely wouldn't get involved in. If they do get involved in them, it's probably because it interacts with other states or has a federal component. So if they don't get involved in, then yes, we may get involved in them to look at them solely from a Nevada perspective under our laws, state laws. I hope that answers your question.
Thank you. And again, I appreciate that. I just walked into it with such I think novice lens is the correct framing here. So I appreciate that. Thank you. Thank you, Madam Chair, for your indulgence.
Assemblyman Flores, Mark Kruger again for the record. Yeah, we understand. And most of the time when we start talking about antitrust, everyone's eyes glaze over. So we get it.
Thank you, Kruger, and thank you, Assemblymember Flores. I believe I have Assemblymember Kasama next.
Thank you, Assemblywoman Kasama, Assembly District 2. For the record, I'm going to copy Assemblyman Flores' phrase of the novice land regarding, and he's an attorney, and so I'm very much in that novice land. And so just a couple things for me to understand, and I don't know if this is a question that Mr. Tucker is still available. He talked about one transaction that it would have been good if he had known, I think, ahead of time or the issues going on there. I don't know if that investigation is still ongoing, the one in Las Vegas. But what was the result? Was it that the merger was stopped, or is it just getting information ahead of time?
Yes, Assembly Member Lucas Tucker, for the record. Under the statute, the information that we obtained is confidential until or unless a complaint is filed to enforce Nevada antitrust laws. And so all I can say is that in that matter, a complaint was not filed. And so the outcome of the investigation is still considered confidential. So I can't really provide you any details other than to say that, once we found out about it, which wasn't until it had closed, we did have concerns, as did the FTC. And because of the timing of that situation, the parties had to kind of pause the closing and hold their assets separate. And so I think in that situation, it would have been better for all parties, our office and the merging parties, if we had found out about it before.
Thank you. Chair, could I indulge with one more question?
Yes, follow up, Assemblymember Kasama. Go ahead.
Yeah, so I'm trying to understand the larger landscape here as well. So if two providers, I know one of the goals is to keep costs down and more choices of service, but aren't some of these consolidations because either party is losing money and they can't continue to perhaps subsidize? I know we have Medicaid cutbacks and other issues in these areas where it sounds like at times they're not even getting their costs covered. And so wouldn't that necessitate some consolidation because one party or the other is losing money? And I'm curious, in a case like that, is it still allowed for the merger to happen even though there'd be less providers in the market, but yet it's a necessity because of costs?
Assemblywoman Kusama, this is Mark Kruger for the record. Thank you for your question. I guess I would answer by stating, first off, the reason for getting notice and for us to take a peek at these transactions isn't to stop necessarily consolidations. It is to make sure that there's a robust market. And if there is case, such as the example that you gave, where the market isn't being affected because one or the other provider is going to be going out of business or is so severely hamstrung from being able to work that the consolidation actually looks like it will actually reduce prices, this isn't going to be an opportunity for our office to say, oh no, we don't want the merger because that isn't going to be helpful for Nevadans. We're looking to help Nevadans by making sure that the competition is out there. So every factual situation is going to require and necessitate an independent review, which is why a notice provision such as that what we're asking for makes the most sense, and early on makes sense too. It doesn't necessarily mean that we're not going to say, yes, we don't have an interest, or yes, go ahead. This merger sounds like it makes sense.
Thank you.
Oops, sorry, I was on mute. Thank you for the question, Assemblymember Kasama. Assembly members, any other questions? Mr. O'Neill, Assemblymember O'Neill.
Thank you, Madam Chair. I'll try to make this real short and quick because it is a gloss over subject. What other states have instituted similar laws, and what effects has it had on trading the benefits in delivery of medicine?
Thank you, Assemblyman O'Neill. This is Mark Kruger for the record. Washington and Connecticut both have passed similar laws. I will go ahead and let Ms. Martin go into the second half of try to answer the second half of your question because she's up on the information about what effect it has. Marie, I think you're on mute.
Yeah. This is Marie Martin. Yes, the laws were passed in Washington and Connecticut. As to economic effects, these laws have been passed very recently, and it is in response to activity to ensure that we are able to capture these types of transactions earlier. In terms of any economic studies that have been done in follow-up, we do not have economic studies in follow-up from either of these states to say, yes, this resulted in lower prices, or it did not result in lower prices, increased quality of service, etc. However, certainly what we can tell you is, from our state's perspective, knowing about transactions earlier rather than later is always good. The ability to be able to review them and have an understanding of them is from our perspective and from the perspective of the businesses who are engaging in these transactions. I think it's also better for them to be able to engage with us earlier and explain themselves. So, for example, if you do have a situation like Assemblywoman Oksama's came up with, where there are pro-competitive benefits, what we call efficiencies stemming from the transactions, we should know about these earlier. And so thank you very much.
Assembly member, this is Lucas Tucker. For the record, I just wanted to clarify that I believe Massachusetts also has a similar law.
Follow up, Assemblymember O'Neill?
If I may, Madam Chair. And I guess we're short physicians and medical providers as it is. And that's what I was looking for, to see if this bill helps attract more because they feel that, or is an interference with attracting and bringing in and improving our healthcare. So that's what I was looking for. So I appreciate the time, and it's a shame that we don't have the information to learn from other states before we jump in the pool. So thank you, Madam Chair. I appreciate it. Thank you, Mr. Kruger and the rest for the information.
Assembly members, any other questions? Thank you so much, Mr. Kruger, Ms. Martin, and Mr. Tucker for your presentation. Seeing no further questions, I am going to move into the support portion of the hearing. I do believe I have somebody signed up to testify on video in the support category. Mr. James Kemp. Do we have Mr. James Kemp available? Okay, broadcasting, can we check the telephone line to see if there is anyone who wishes to testify in the support?
Yes, Chair.
Position?
To testify in support of AB 47, please press *9 now to take your place in the queue. Caller with the last 3 digits of 484, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hi, this is Maya Holmes. Can you guys hear me?
Yes, Ms. Holmes, we can hear you.
Hi. Oh, great. Okay, thank you. Good afternoon, Chairwoman Hargey and Vice Chair Carlton and committee members. For the record, I am Maya Holmes. It's Mayahholmes. I'm the Healthcare Research Manager for the Culinary Health Fund. And we are a nonprofit health fund that provides comprehensive health benefits for approximately 60,000 culinary members and their dependents, about 125,000 lives. Our priority is ensuring access to high-quality, affordable healthcare in Nevada. For public and private payers and patients, healthcare dollars are precious and in limited supply. Healthcare is a critical need, and we must all be effective stewards of those monies. Healthcare prices in the U.S. have increased at a staggering pace over the last 30 years, and healthcare consolidation is a primary driver. Nationally, there has been tremendous consolidation in the healthcare industry, and experts expect that to only increase with COVID. We must understand and address those issues in Nevada. We support AB 47 and appreciate the Attorney General's work on bringing this important bill forward. The bill takes essential steps towards protecting competition in Nevada's healthcare markets and ensuring Nevadans have access to quality, affordable healthcare established through a robust and competitive market. However, we do request that the Attorney General share the summary information provided in Section 2, Subsection 2, with state agencies such as DHHS and the Patient Protection Commission after the transaction is completed. It's a very narrow list of reported information that's publicly available but currently not collected or aggregated in a systematic way that's really efficiently or easily available to state agencies. We understand that there's certain information that the AG's office needs to remain confidential for its investigations and antitrust work with the FTC, DOJ, and other states. Still, we do not see how the specific summary information listed in the section falls into this category. Connecticut makes this information available to the public by posting it on a state agency website after the transactions are done. And the last point I want to make is one of the Patient Protection Commission's mandates is to examine the cost of healthcare and the primary factors impacting those costs. We know consolidation is in healthcare is a driving, if not the driving factor in healthcare costs. This information is vital for the PPC to fulfill its mission and essential to other state agencies responsible for monitoring our healthcare system. Thank you so much. I appreciate your time.
For your testimony. Broadcasting, next caller, please.
We are currently on support of AB 47. If you recently joined the call and would like to testify in support, please press *9 now to take your place in the queue. Again, please press *9 now to take your place in the queue. If you are a new caller and would like to testify in support of AB 47, please press *9 now to take your place in the queue. Will the caller with the last three digits of 486 please slowly state and spell your name for the record? You'll have 2 minutes and may begin.
Good afternoon. This is James Kemp, K-E-M-P.
Thank you for joining us, Mr. Kemp, when you're ready.
Thank you. Good afternoon, Chair and the committee. I'm James Kemp on behalf of the Nevada Justice Association, and we are in support of AB 47 and particularly the provisions that restrict employment covenants not to compete, which is Section 14 of the amendment. We liked the bill as originally proposed. We liked that better. It would have completely eliminated employment covenants not to compete. But what we have here in Section 14 of the amendment is definitely a huge improvement and positive step for employees in Nevada. These agreements are often merely designed to frighten employees. They have the effect of suppressing wages. It prevents employees from getting the maximum wage that their talents will bring them in a free market. It requires employees and their families to often have financial difficulties, may have to relocate to another state out of Nevada. And it can have a particularly hardship effect on older employees. Example, I have a client now in my employment law practice who is in his late 60s, who is going to be held to a one-year covenant not to compete when he's got maybe just 2 or 3 years left in his working life. And he's only worked in one industry. Just this one particular narrow industry is all that he's ever worked in. So it's going to be a terrible hardship on him and eliminate some of his remaining working life. So these covenants not to compete, any way that we can restrict them is something that Nevada Justice Association is in favor of. I think the fee shifting provisions in this will be very helpful because often employers do try to enforce covenants not to compete that are overbroad and unenforceable. And this would, in this provision, employees would have the ability to recover attorneys' fees and costs if they're successful in challenging a covenant not to compete. And that can be important because, as I often tell people, just having to fight one of these out, you lose because you end up having to pay money and fees and costs. And oftentimes, if you lose, you can be forced to pay fees and costs of the employer. Also, the new employer, if somebody goes out and gets a new job and it turns out to be in violation of the covenant not to compete, new employers can often face litigation, and that certainly sours the new employment relationship as well. So any restrictions on covenants not to compete are good, and the Nevada Justice Association is in favor of and supports AB 47 in this regard. Thank you.
Thank you, Mr. Kemp, for your testimony. Broadcast, next caller.
If you recently joined the call and would like to testify in support of AB 47, please press star 9 now to take your place in the queue. Chair, there are no more callers in support at this time.
So much, Broadcast. We will now move into those who wish to testify in opposition of Assembly Bill 47. I do believe I have a few people signed up to testify virtually. We can start with Mr., I believe it's Jesse Wadhams, Nevada Hospital Association.
Yep.
I'll go with Mr. Wadhams.
Thank you, Chair. Good afternoon, Chair Howdigi and members of the Commerce and Labor Committee. My name is Jesse Wadhams. It's JESSE-WADHAMS with the law firm of Black & Wadhams, appearing on behalf of the Nevada Hospital Association. First, I do want to thank the Attorney General's office for their engagement. Mr. Kruger, Mr. Tucker, and Ms. Martin have been very engaged, and it's a great credit to Attorney General Ford's office. He opened that statement with a working group and has held to that. Ultimately, though, while that engagement has been productive, I'm afraid we are still opposed to this bill. The Nevada Hospital Association has been working with other stakeholders, including the Nevada Association of Health Plans and the Nevada State Medical Association, as representatives of Nevada's healthcare delivery system. We have put together some joint comments which, with your indulgence, Chair Howdigi, we will get into the system. My comments actually today are mostly actually based on a slightly earlier version of the bill. I'm afraid we got a bill, we got a proposed amendment on the March 11th, and it is slightly different on Nellis, which appeared about 40 minutes before the hearing. So if you'll just kind of indulge that, I may have a little bit of cross, but we're still reviewing those, and at this moment we are still opposed, at least on the first reading. Ultimately, Nevada's hospitals, I think like every other stakeholder group here, we've had transactions reviewed by the Attorney General's office, and that process is not only in depth, it can often result in substantial changes to the transaction as required by the Attorney General's office. And I do want to make a point clear that builds off Assemblyman Flores' question earlier. This is not the same reporting as goes to the Federal Trade Commission under Hart-Scott-Rodino. This is a new, separate entity, burden of reporting on healthcare entities only, and it is new, it is different, it is not in sync with those standards. At the end of the day, ultimately, the need for this, based upon the fact that the Attorney General has reviewed these, the need for this bill just remains elusive. We just don't know what the underlying goal is. The bill diverges significantly from federal reporting standards and definitions. The report would include granular data that can be the subject of negotiation not only at 30 days prior to the deal points, but throughout the entire negotiation process all the way up until the end. And I do appreciate Mr. Kruger making a note of the businesses providing services. That language to the lawyers probably gets a little there's a lot of things that could fall under that definition. So I do think that will need some additional work. Washington and Connecticut, those are the two I've looked at. Mr. Tucker referenced Massachusetts, and I'm not familiar with that one. But neither of those states go so far and require the level of reporting or this particular definition of material change. Section 7, sub 10 has changed a fair bit, so I do want to spend a little time looking at that, but that's that material change standard. I do know that that's, again, Washington and Connecticut have a much more defined version that gives you a little bit more understanding of the reporting parameters. This also sweeps in a lot of internal contracts, a lot of things that are not consumer facing at all, even those that are even within a parent subsidiary in the same company. So looking again at, and then you look at the burden, $1,000 a day for fines that are on on a small subset of reporting entities for all manner of transaction. Not only is it $1,000 a day penalty, but let's not forget that NRS 598A has criminal penalties attached to it. This is a criminal statute. And while it's a subtle point, I also want to make a note of the change in Section 10 to add agencies, boards, and commissions to the oversight authority of the Attorney General's office. Those particular entities, those will often have market participants and are part of the regulatory oversight of a particular agency. And I think that raises certain constitutional issues that the Supreme Court, I think, has looked at even as recently as the North Carolina FTC case. Yes.
I know I do have a few more people signed up to testify in opposition. So I just wanted to see if you could wrap up your remarks and if there is something in writing to send over to our committee manager to share with the committee. Thank you.
You got it. And let me just simply say at the end, we are still concerned about the chilling effect on the movement of capital, the ability to recruit physicians, and the new mandate on providers in the middle of a pandemic that is still going on. But we'll work with the Attorney General's office and keep you posted.
Thank you, Mr. Wadhams. And I believe next we also have on video Mr. Clark. Tom Clark, are you with us?
I am. Thank you, Madam Chair, and members of the committee for allowing us to sit at the table, as you might have, what we might have done in the past with Mr. Wadhams. He has outlined our concerns. We've enjoyed working with the Nevada Hospital Association and also with the Nevada Medical Association. Three groups that don't normally sit at the table together on these particular issues. Mr. Wadhams has outlined our concerns quite well, and I would yield my time to others that come forward in opposition. Thank you, Madam Chair.
Thank you, Mr. Clark. We appreciate your testimony. Broadcasting, did we check the telephone line to see if there is anyone else signed up who wishes to testify in opposition?
Madam Chair.
Yes, Chair.
Madam Chair, this is Assemblyman Flores.
Yes, Mr. Flores?
Thank you, Madam Chair. If I could ask for a point of clarification, and I apologize for speaking out of turn. I just want to make sure that I'm looking at the right document. I heard Mr. Wadhams reference Section 7, sub 10, but I'm looking at the amended document that was provided and attached to Nellis as an exhibit. Is that the same document that everybody else is referring to when we talk about the amended version of the bill? Or is there a separate document that I may have missed? I just want to make sure that I'm looking at the correct document, as I don't see a subsection. I see a section 7, but I don't see a sub 10, and I want to make sure that I'm looking at the right thing.
Madam Chair, Mark Kruger, I think I can provide some information on this.
Thank you, Mr. Kruger.
Madam Chair, members of the committee, Assemblyman Flores, I think Mr. Wadhams misspoke because he was looking at a prior iteration of the amendments. The current amendment you are looking at was the one that was sent in, and the specific language that Mr. Wadhams was referring to is in Section 6, subparagraph 8.
Thank you for the clarification, Mr. Kruger. We appreciate that. And you said that was Section 6, sub 8.
Paragraph 8, right. And that's where it says means any transaction that results in a material change.
Thank you, Mr. Kruger.
Chair, for your indulgence. Thank you.
Thank you, Assemblymember Flores. We appreciate you pointing that out so that we're all on the same page. Okay, broadcasting, if we could go back to check the telephone line to see if there is anyone who wishes to testify in opposition.
Madam Chair, if I may
Yes,
just
Chair.
quickly, if I may just for the record really quickly clarify that it's Tom Clark, TOM-CLARK. I'm speaking on behalf of the Nevada Association of Health Plans. I don't believe I got that in previously, and I want to make sure that for the record that that's recorded. Thank you.
Thank you, Mr. Clark. We had it all noted from your registration, so we appreciate you registering and identifying which organization you were representing. Okay, broadcasting, let's go back to the telephone lines to see if there is anyone wishing to testify in opposition.
Yes, Chair. To testify in opposition of AB 47, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 018. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
This is George Ross, GeorgeRoss, speaking on behalf of HCA Healthcare. HCA opposes AB 47. Make it clear that we really appreciate the opportunity the Attorney General has given our industry and us to participate in the preliminary versions of this bill and to make our concerns known. And we do know he has made a number of changes. However, we echo the concerns of the Nevada Hospital Association. In particular, we are concerned about the reporting that's required beyond mergers and acquisitions. Quite simply, those requirements will directly impact negatively the industry's ability to provide quality care in a timely and cost-effective manner. Thank you.
Thank you, Mr. Ross, for your testimony. Broadcasting, next caller, please.
Caller with the last 3 digits of 505. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last 3 digits of 505. To unmute, please press star 6.
Hi, this is Peter Guzman, President of the Latin Chamber of Commerce. Thank you for allowing me to speak for a few minutes. The Latin Chamber supports the general concept of punishing bad actors, but at this time must join some of our colleagues in opposing this bill as currently written. We appreciate the Attorney General's office working with the business community. However, this bill will have a negative impact on our very important healthcare partners and members, particularly as the pandemic continues. We look forward to continuing the conversations with the Attorney General's office regarding our concerns. Thank you, Chair and committee members, for your time today.
Thank you, Mr. Guzman. We appreciate your testimony. Broadcasting, next caller, please.
If you recently joined the call, we are on opposition of AB 47. To take your place in the queue, please press star 9. Caller with the last 3 digits of 582. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Madam Chair, Chair Howdigi, and members of the committee. My name is Jaron Hildebrand, and I am the Executive Director of the Nevada State Medical Association, which represents Nevada physicians. While our membership consists of doctors across the state, we are first and foremost a patient advocacy organization. Today, I am testifying in opposition to AB 47. While we appreciate the communication with the Bureau of Consumer Protection and we recognize this bill has been narrowed, likely as a result of many conversations we have had on this proposal. However, the draft remains overly broad and places unnecessary burdens on healthcare providers. This bill will place additional administrative paperwork on our doctors and their staff at a time when we are responding to a global pandemic and still facing 6% Medicaid cuts. While this increase in healthcare costs and reduce access by taking the physician's attention away from their patients. Most of our transactions are not a concern. And it can't be emphasized enough that the Attorney General already has the ability to intervene where there is a reason for concern. As drafted, this bill not only sweeps in medical contracts, but we believe it captures all transactions, including legal, accounting, HR, and nearly everything a small business does. For an example, 2 primary doctors in southern Reno and South Reno, who see dozens of patients a day, must merge to save an administrative and building costs, keeping up and possibly expanding their patient base. All positive things. This type of transaction should not be viewed as anti-competitive behavior, and additional burdens should not be placed on these types of small, family-oriented community healthcare providers. This bill presumes that all healthcare transactions are suspect and will likely have a chilling effect on our system of healthcare, which will negatively affect Nevada families and your constituents. Small practices throughout the state, which are included in this bill, are facing lower than normal patient volumes due to the pandemic. However, this bill will make it more difficult for doctors' offices to remain viable and keep their doors open. Physicians want to care for their patients. They are healers. This at its heart of what they do every single day, and that the oath that they take. NSMA understands the importance of a strong Consumer Protection Bureau, but we believe it is unclear how requiring extensive reporting on small practices will strengthen the mission of the Bureau of Consumer Protection. And most importantly, we believe AB 47, as currently drafted, will reduce access to care, which is why we still stand in opposition today. Thank you, Madam Chair. And I apologize. I know I was supposed to be on the Zoom link. It says I'm still waiting to be admitted, but I called in anyway. So thank you again for your time, and I appreciate it.
Mr. Hildebrand for calling in and testifying. Broadcasting, can we go to the next caller, please?
Yes, sure. Will the caller with the last 3 digits of 124 please slowly state and spell your name for the record? You'll have 2 minutes and may begin.
Good afternoon, Madam Chair and members of the committee. For the record, Paul Moradkin, Moradkhan with the Vegas Chamber. First, I'd like to thank the Attorney General's office on their outreach to the business community regarding AB 47. I appreciate their openness in receiving feedback as we work through our concerns about this bill. I would like to thank Mark Kruger with AG's office for facilitating many of these conversations and for the several drafts that we've been working from. As you have heard, this bill has 3 main policy components. We have worked through our concerns about the non-compete clauses, which we believe in the current draft is a good balance between employees and employers, and a follow-up to the Nevada State Court ruling in 2016 and the passage of AB 276 in 2017. In the original draft, the merger and acquisition piece, we were concerned about the broad scope of how it would impact Nevada's business climate, and we believe that the latest draft, the narrowing of the language, mitigates many of those concerns. However, our opposition today relates to the third part of the bill, which are the healthcare provisions. As you have heard, many of our healthcare members continue to have concerns about these provisions. This includes how this bill will overlay with the federal regulations of the Hart-Scott-Rodino Act, the confidentiality of the documents, and the penalty structure, to mention a few. But we know there's still an opportunity to address those concerns, and we appreciate that from the Attorney General's office. With that said, we will make the commitment to continue to work with the Attorney General's office to find a solution that will help us address the nexus of the bill. Thank you, Madam Chair and members of the committee, for your time today.
Thank you for your testimony, Mr. Moradkin. Broadcasting, next caller, please.
Will the caller with the last 3 digits 054 please slowly state and spell your name for the record? You'll have 2 minutes and may begin.
Good afternoon, Chair Howdigi and committee members. My name is Leslie Pittman, L-E-S-L-E-Y-P-I-T-T-M-A-N, and I'm here today representing Reno Diagnostic Centers, the only independently owned diagnostic imaging facility in all of northern Nevada, with 2 locations in Washoe County. RDC has been in business for more than 30 years, has 3 board-certified radiologists on staff. We're the first to bring MRI technology to Nevada and serve thousands of residents annually throughout northern and rural Nevada. We appreciate the Attorney General's intent behind AB 47 to provide greater oversight of mergers and acquisitions to help ensure the results of these activities do not negatively impact Nevadans by reducing choice and increasing costs in the healthcare marketplace through consolidation. We've also appreciated the opportunity to share our concerns with the Attorney General's team. However, we remain concerned with how this bill would go about achieving its objectives. Namely, we are concerned with the definition of group practice in Section 6 as, quote, 2 or more providers, and subjecting small operations like ours to the reporting requirements outlined in Section 2. It's important to note that each new regulation or requirement that is mandated on small healthcare operations comes with increased costs, as it often requires the hiring of additional staff or increased time and paperwork for existing staff to maintain compliance. Any new mandates must be considered judiciously, as they come with the reduced ability of smaller operators to compete with larger provider organizations. As I mentioned, RDC has been in operation for more than 30 years. During that time, they have been on the receiving end of many acquisition offers. They have consistently declined these efforts because they know members of the community both deserve and demand continued access to low-cost, high-quality diagnostic imaging. Increased regulatory requirements impacting the cost of doing business will make those acquisition offers more attractive, thereby further consolidating the healthcare marketplace, something that appears to be the opposite of what this bill seeks to achieve. Thank you for your time, and that concludes my remarks.
Thank you. Broadcasting next caller, please.
Caller with the last 3 digits of 836. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. For the record, it's Jessica Ferrato here today on behalf of the College of Emergency Physicians. Just as some background, emergency physicians are the frontline workers, as you all know, working through this pandemic to care for our most vulnerable populations. We're not able to take, we have to take all and every single patient that comes through the door, and the pandemic has illustrated the shortage that we have statewide. I want to thank the Attorney General's office for all of their work and inclusion in meetings to work on this bill. We obviously still have some concerns. I'd like to reiterate the comments by my previous colleagues and also highlight just a few sections that have been mentioned previously. We have concerns over the reportable transaction language and concern that will include internal contracts as well as employment, contracting with the insurance industry, concerning on hiring. We're looking to hire doctors, many from out of state, to bring them to Nevada, and are concerned that will be swept into this legislation. And we already have a doctor shortage throughout the state and have concerns from a recruiting perspective. We also have concerns in Section 5 on the civil penalties, which feel relatively heavy-handed, as it will be $1,000 per day for violations without any language on willful violations or otherwise. Again, we look forward to continuing our work with the Attorney General's office and appreciate your time.
Ms. Ferrato, thank you for calling in for your testimony. Broadcasting next caller, please.
Caller with the last 3 digits of 781. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. Nick Vanderpool, NICKVANDERPOEL, with Capital Partners today representing the Reno Sparks Chamber of Commerce. While we appreciate Attorney General Ford and his office working with stakeholders, and I can say it was a very healthy conversation on Assembly Bill 47, and we found some common ground, but in the end are still opposed to the bill as written. We share the same concerns that some of my colleagues outlined before me, and the potential implications the bill would have on healthcare in Nevada. So I'll keep it short, as many have reiterated what has already been said. So I thank you, Chair and committee members, for your time.
Thank you for your testimony. Broadcasting, next caller, please.
Caller with the last three digits of 969. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon. My name is Brian Wachter, BRYANWACHTER, Senior Vice President with the Retail Association of Nevada. In the interest of time, I would just like to echo the comments of Paul Morakin at the Vegas Chamber, and we appreciate the Attorney General's office for working with stakeholders on AB 47, and at the moment we are in opposition to the bill.
Thank you, Mr. Wachter. Broadcasting, next caller, please.
Caller with the last three digits of 114. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hi, greetings, Chair Howdigi and members of the committee. My name is Amber Stidham. That's Amber, last name Stidham, Stidham. I'm testifying on behalf of the Henderson Chamber. Also want to say we appreciate the Attorney General's office and certainly Mr. Kruger's willingness to work with stakeholders. And we too echo a lot of the sentiments that our friends in healthcare had expressed earlier today. Just as perhaps a newer aspect that our organization remains in opposition to is really in regards to Section 14 of this proposed bill, which really seeks to amend NRS 613 as it would apply to all employers, not limited solely to healthcare entities. It's our understanding that we believe that this proposal listed regarding the enforcement and remedy process continues to be extremely punitive. As it stands, Nevada law outlines of various criteria that must be demonstrated during a case to determine a non-competition covenant is enforceable. Many of these actions, though, can be subjective in its legal determination. That, coupled with the language suggesting employers may not bring a cause of action to enforce a covenant not to compete, along with punitive mandatory awards of attorney's fees, which is enhanced by the addition of the contextual language used, such as shall versus may, that's listed within, we believe will still have a direct effect on existing agreements among employers and employees. We also believe effective rules are already in place to protect these workers who are not violating non-competes, and that this should still bear out in court as it stands. We would like to see AB 47 continue to be refined. We continue to remain committed to ongoing conversations, and we thank you for your time.
Thank you for your testimony, Ms. Stidham. Broadcasting, next caller, please.
Caller with the last three digits of 503. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Hello, my name is Chris Bosse. That's CHRISBOSSE. I'm representing Renown Health for the record. Today, I'm here testifying in opposition to AB 47. While we very much appreciate the open process the Attorney General and staff have provided on this complex bill, we believe the current version of this bill still does not address our concerns regarding the impacts of the significant reporting requirements and potential gaps in confidentiality protections could have on the healthcare industry. This is while, and we agree with the Attorney General's office, the AG already has the authority to access any documents, information related to antitrust matters. We're supportive of reasonable transparency, but would like to see some narrowing of scope of transactions that need to be reviewed so not to put an unreasonable burden on healthcare providers and facilities. We support the comments made by the Nevada Hospital Associations and many of the others who spoke before me today, and hope to continue working with the industry and the Attorney General's office on further refinements. Thank you for the opportunity to speak.
Thank you for your testimony. Broadcasting, next caller, please.
Chair, there are no more callers in opposition at this time.
Thank you, Broadcasting. And we will now move into testimony in the neutral position. I don't believe I had anyone signed up to testify in the neutral position on video. So broadcasting, could we please check the telephone line?
Yes, Chair. To testify in neutral on AB 47, please press *9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Thank you, broadcasting. Mr. Kruger, are you with us still? There you are. Mr. Kruger, would you like to give any closing remarks or final remarks?
Chair Howdy, thank you, Mark Kruger. For the record, I'll keep them very brief. Madam Chair, members of the committee, thank you for your consideration of AB 47. To be clear, the intent of this first focus of AB 47 is to allow the antitrust team an opportunity to take a peek at transactions that may very well affect the cost of healthcare in Nevada and ensure competition in the healthcare market for lower costs. The simple 1 to 2 page report is not related to the recruitment or retention of physicians in Nevada. It is not onerous, and it is in the best interest of the state and all the parties to a healthcare transaction. In addition, the intent is to limit the scope to healthcare transactions, not capture janitorial type contracts. The penalties are up to $1,000 per day, allowing for that discretion of up to, but strong enough to discourage blatant disregard. The numerous versions and changes we have made to AB 47 address the concerns and have resulted in a narrow and focused bill. We hope we have addressed many of these concerns that you heard today. We look forward to continuing to work with stakeholders, and we thank you all for your time.
Thank you, Mr. Kruger. I will now close the hearing on Assembly Bill 47. The last item on our agenda today is public comment. While we give those listening over the internet an opportunity to call in, I will read through some public comment housekeeping. I would like to remind the public who's listening that public comment is an opportunity to discuss general matters that fall within the purview of this committee. The public has already been given time to support or oppose a specific legislation. We open and close hearings on bills so that we establish a record of the public testimony on a bill. Therefore, public comment is not intended to continue a bill hearing. We may limit public comment to 2 minutes. Please remember to address your remarks to issues that fall within the jurisdiction of the Commerce and Labor Committee. If you direct your remarks to issues over which this committee has no oversight, I will ask you to redirect or terminate your remarks. Please be respectful of committee members and other witnesses. Do not comment on testimony provided by other speakers, and do not make personal attacks. You may always submit written remarks for inclusion in the meeting record. With that, broadcasting, is there anyone signed up to give public comment today?
To take your place in public comment, please press *9 now to take your place in the queue. Caller with the last 3 digits of 635, please slowly state and spell your name for the record. You will have 2 minutes and may begin. Caller with the last 3 digits of 635, to unmute, you can press *6.
Thank you for your patience, everyone. My name is J.C. Giancarlo, Johncarlo, and I need all the senators from Vegas to listen, from Clark County. I've got a lot here. So basically, I do think we need to entice doctors to come here, so y'all should listen to that. And then also, let me see, we have some of the highest car insurance rates in America, so I would like for you guys to try to lower that for us. And the state should say something about electric car failures. I've seen pictures of Teslas running into buildings, which may cause death and damage to property, so that might higher insurance rates. Teslas or other electronic vehicles failures should lower the luxury car cost, which would help lower our insurance rates. For your information, insurance rates, and don't pass state legislation that is going to increase insurance policies like girls getting hurt against boys competing in high school. So I want to stand up for the young girls that have to compete against boys. I don't think that was the right move by some of y'all. Illegal immigration hurts the wage of American workers. So you guys, the state should be doing something like taking businesses' licenses. If they're hiring illegal immigrants, would you guys know that is happening? Let me see. Yeah, so illegal immigration, you guys need to do something about that because you guys are basically enticing immigrants to come to Nevada, which will raise our Medicare costs. It will raise teachers' costs. It will raise the cost of many other things. So this topic has been long past due. Yeah. All right. Thank you, guys. That's it.
Thank you for your comments. Broadcasting, is there anyone else on the line wishing to give public comment?
Chair, the public line is open and working. However, there are no more callers at this time.
Thank you, Broadcasting, and thank you, committee members, and thank you, presenters and those testifying. I know we're still working through virtual meetings, so I appreciate everyone's patience as we work through the technicalities of virtual meetings. With that, that wraps up our committee meeting for today. Our next meeting will be on Wednesday at 1:30. Thank you, committee members. We are adjourned.
Thank you, ma'am.